mean, Robert.
All right, I hope everyone had a great lunch. And everyone, just give me one moment before we start. All right, Ms. Gonzalez, I'm going to send you to a breakout room with your attorney, so your attorney will be able to go over paperwork with you, okay? So just give us a moment. And who is the person who's listed as Jasmine iPhone?
Okay.
Jasmine, I have court today at 2.
All right, just give me a moment. Ed Shaughnessy?
Yes, ma'am.
All right, who is your client? Is it the person who's in custody?
Yes, Judge. It's both Jasmine and Josefina. They're both.
Which is the person who needs the paperwork?
Gonzalez. Josefina Gonzalez.
All right, Ms. Gonzalez, you should see on your screen where you've had an invitation to go to a breakout room. Please go to breakout room number 1.
Judge, this is Hunter.
Yes.
I had sent the paperwork to Ed's personal email per request. Do I need to send it to the courtroom computer?
Norma? Norma would be in the best position to answer that question.
Let me ask him. Give me one second.
Okay.
All right, everyone, just give me a moment, please.
Hunter, can you send it to me to my email?
Sure. I'll replace his email with your email, so it should be there in just a few minutes.
Okay, thank you.
All right, Norma, that has been done. It should be on your way, on its way.
Thank you, Hunter.
Judge, I'm gonna have to restart my computer.
Okay, they have finished the paperwork on Miss Gonzalez, I believe it is. And so they're going to bring that to me and we will take her up. And then I think the last thing we have on the docket will be the motion to quash. Okay, I thought we were ready because I've signed everything, but there's more conversation that is happening. Rebecca, how is your computer? Your brand new computer that was provided, I guess, by the county that is not working on a regular basis?
It's working just fine as of this second. Don't let me send out anything.
Okay, see, the fact that you said that, you sort of jinxed it a little bit. So we're gonna now have to cross our fingers.
I just can't make any Word documents. So
Okay,
I have to save all my documentation until we're done with court.
uh, Brenda, I think I may have to go into the breakout room.
Okay, I'm Googling computer shuts down every time I open Word.
Oh my gosh.
Let's see if there's a way to fix it.
Maybe my computer thinks I'm working too hard.
There you go.
Have you asked IT?
No, because by the time it's already gonna be the end of the day for them to leave. So I don't know who.
Yeah, I don't think it should be happening every day. Oh, here it is. Rebecca, I'm gonna send you this. Maybe it will work.
Okay. Whatever it is, I'm gonna do it after.
Yeah, after court.
After court. That's a lot of instructions. I'm just kidding.
It was more for Vista. It might work.
I'll try it. You're our go-to to fix anything and everything.
Mm-hmm.
All right, are you all ready on Miss Gonzalez?
Your Honor. Yes, Your Honor.
Whatever you think is best. Like I said, it's just an hour. I'm not asking for anything.
Court reporter's loosening up, Your Honor. State's already loose.
All right, the court is calling 2020 CR 2119, State of Texas versus Josephine Gonzalez. Can I have parties announced for the record for the state,
Madam Morris for the state.
for the defense?
Ed Shaughnessy for Miss Gonzalez, Your Honor.
All right, and Mr. Shaughnessy, if you could move back a little bit and turn to your right. Yes, stay right there.
Okay.
Yeah. We were just getting a nice profile.
Is that on the record, the laughter?
Yes, it is.
No.
It's put down as laughter. All right, we're proceeding by video because of the pandemic. Any objection from the state or the defense?
I'm from the state, Judge.
Well, if it gets me on my right side that you want, I don't have any objection.
Yep, you're on the right side. Miss Gonzalez, did you sign a document?
And no objections, Your Honor.
Thank
Away
you.
from this file.
Mr. Gonzalez, Miss Gonzalez, did you sign a document entitled Defendant's Consent to Plea by Video Conference? And did you review that with your attorney and understand it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Did you also sign a document entitled Application for Deferred Adjudication or Community Supervision? And
Yes,
did you
ma'am.
review it with your attorney?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review a document entitled True Bill of Indictment with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we are proceeding on a lesser included offense. Possession with intent to deliver a controlled substance, penalty group 2A, and an amount from 1 to 4 grams. And we'd waive count 2 of the indictment.
Any objection?
None, Your Honor.
All right, Ms. Gonzalez, did you review a document with your attorney entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions?
Yes, ma'am.
Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand, the state is proceeding on count one, but they're going on the lesser included offense of possession with intent to deliver a controlled substance?
Yes,
Felony
ma'am.
group 2A,
Oh.
1 to 4 grams. That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement? I'm
Yes, ma'am.
sorry, it has been a long day. Just 1 second. Do you understand that if the court does not follow your plea bargain agreement that you've reached with the state and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea? Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
You intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Very much so, Your Honor.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense in count one of possession with intent to deliver a controlled substance. Felony group 2A, 1 to 4 grams. They're asking that your punishment be assessed at 6 years in the prison. There's a $0 fine. The state will remain silent on your application for deferred adjudication or community supervision. There will be restitution in the amount of $57 for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, ma'am.
Mr. Shaughnessy,
Oh,
is that the plea bargain agreement?
Yes, Your Honor, it is.
State,
Very
is that the plea
generous.
bargain? State, is that the plea bargain agreement?
It is, Judge.
Ms. Gonzalez, did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it and did you electronically sign it in both places?
yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then Ms. Gonzalez, to the lesser included offense of possession with intent to deliver a controlled substance, penalty group 2A, 1 to 4 grams. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offer states one of the attachments, Judge.
Any
Reviewed,
objections?
Your Hon- Been reviewed, Your Honor, no objection.
All right, Ms. Gonzalez, did you review a document with your attorney entitled waiver and consent to stipulation of testimony and stipulations? Did you
Yeah.
understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you applied for deferred adjudication. Norma, when can we bring this back for sentencing? She'll need a PSI. And Mr. Shaughnessy, does she need a TAP evaluation?
That probably would be best, Your Honor.
All right. And Rebecca will need a TAP evaluation.
Yes, ma'am.
And Ms. Ferguson, when do we need to bring her back?
On the 16th.
All right, so we'll come back on June 16th, Ms. Gonzalez. At that time, the court will make a decision on your application for deferred adjudication or community supervision.
Okay.
Your Honor, I have
Sorry.
one more request from the court when you have a minute.
That will be based upon the report I received from probation and any other evidence that's presented to me. Do you understand, Ms. Gonzalez?
Yes.
All right, Mr. Shaughnessy, there's something else you
Yes.
wanted to present?
Yes, Your Honor. My client is currently in custody, remanded without bond. Apparently, there was some COVID-related communication issues which resulted in a failure to appear. Inasmuch as this matter has been resolved in part by the entry of the plea of guilty, we would ask the court to set a bond pending the PSI hearing.
All right, when was she arrested?
I don't have that information.
Ms. Gonzalez, when were you taken into custody?
April 27th.
So she's been missing since October because a warrant was issued for her on October 15th, 2020. So where has she been since April?
Can you explain that to the judge, Josephine?
Yes, I have always been reporting to the bail bonds, been calling to the courthouse. When was my court? And I've never gotten any answers to it.
No. The bondsman, your bond was forfeited on October 15th, 2020. And on that day, you were remanded without bond. So there would not have been a bondsman for you at that time. So you've been missing since October. So that's been November, December, January, February, March.
April, 6 months.
Yes. So it's like, where have you been? Why haven't you turned yourself in? Why haven't you called the court to ask to appear or to be placed on the docket? That's a problem.
I didn't even know that I had a warrant, because if I did, I would have had turned myself in.
Well, I mean, if you would have showed up for court, you knew you had a case, right?
Yeah, yes, I did. I knew I had a case, but I've never known that I had a court date. And I would always call.
No, because you were here June 18th, 2020. I placed everything on the docketing sheet. So you actually showed up for that because on that day, an offer was tendered to you and it was given to you. And then we came back October and you didn't show up and you've been missing ever since then. It sounds to me, Ms. Gonzalez, like sometimes people, you know how little children are. I'm not saying you're a child, but you know how children are when they're like, if I just bury my head in the sand, then maybe
Yes.
stuff won't happen. But here, this is where we are though. State, are you in agreement for a bond for her?
Judge, the state would be fine with the bond as long as the defendant's admonished that this court's open in the full range of punishment should she fail to appear for sentencing. And the state would ask for partial GPS.
Mr. Shaughnessy?
Well, I'm always GPS is so expensive, Your Honor. We're only talking about it less than a month. Whatever the court feels is appropriate, Your Honor. You know the ins and outs of GPS as well as I do.
All right, so what bond amount are you requesting?
Your Honor, I'd like the court to set a $10,000 bond if the court feels it's appropriate.
All right, state? I don't know her criminal history.
State's in agreement with that, Judge.
All right, so I'll set the bond at $10,000. If you all will send me a email with your agreement in it, please. So bond, $10,000. Partial GPS. I'll say waive fees in place on indigent status. All right, Ms. Gonzalez, your next court date for this court is June 16th.
Okay, I'll be here
So what's your next court date?
June 16.
All right, and you need to make sure you appear in the 187th District Court. It's 300 De La Rosa on the 4th floor. Do you understand?
Yes, ma'am.
All right, so when's your next court date?
June 16, 187, 300 De La Rosa,
At 9 a.m.
9 a.m.
Mr. Shaughnessy, do you have all her contact information?
I could probably use a little more, to be honest with you, Your Honor.
Okay, so what I'm going to do, I'm going to send you and Mr. Shaughnessy and probation in a breakout room. So probation will be able to tell you what you need to do. So I'm going to send you all, Mr. Shaughnessy, if you'll go to breakout room number 2.
Okay, will do.
Ms. Gonzalez, I'm going to send you to 2, and Rebecca, if you'll go to 2.
Excuse me, Judge, with her being on bond, does that change the PSI, the sentencing date?
Well, the only thing is, I don't know if she's actually going to be on bond. That's the problem.
Okay,
I don't know if she'll bond out or not.
okay.
But if
Yes,
she
I was-
does,
I was
then
just
we may end up
inquiring.
changing. But you know what? We'll still have her come, so we'll know where she is.
Okay, thank you.
Thank you. All right, so I am here on a motion to modify bond conditions. Is that for? Okay. All right. I just received an email from the state saying that they have no objection. Is it for both cause numbers?
Yes, I think.
All right, Tom Nesbitt, is this an agreement for both cause numbers?
Yeah, that's fine, Judge. They're just asking for one additional hour on the window, and that is no objection to both cause numbers.
Okay, then this was a quick hearing. So I will sign that. Just give me a moment and you can get a copy.
Thank you. Have a good weekend, everybody.
Thank you, you too. And Norma, she may or may not end up.
Think she shows up or not?
Marcus, are you the person who's on the motion to quash?
Yes, Judge.
Okay. Well, as soon as Shaughnessy comes back from the breakout room, we'll take that up.
Okay.
Jasmine Hardaway, I need you to show your video and unmute yourself.
Yes, ma'am.
All right. Thank you. Just give me one moment. I'm going to see if they're ready in the breakout room. Please, so that Mr. Shaughnessy can come back. The quickest way to get people to come back to the main room is just shut down the rooms, right? Court is calling 2021 CR 11.
1111.
Well, no, I'm not getting any, there it is. There's a delay. Everybody's computers are acting up. Norma says her computer is acting up as well. So who knows what's going on? So the court is calling 2021 CR 1111, State of Texas versus Jasmine Hardaway. Could I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Ed Shaughnessy, Your Honor.
All right, and are you Miss Hardaway?
Yes, ma'am.
We're proceeding by video with this hearing because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Ms. Hardaway, do you have any objection with this hearing taking place by video?
No, ma'am.
All right, defense has filed a motion to quash the indictment. State, have you had a chance to review that motion and are you ready to proceed?
Yes, Judge, state's ready.
All right. Defense, are you ready to proceed?
Yes, Your Honor. Does the court have a copy of the motion? Last time,
Yes.
there was some confusion about whether you had a copy or not.
Yes, the court has a copy of the motion.
Well, it has not been amended. So it's the only pleading that we're here on today.
All right, you may proceed.
Your Honor, the court has in front of it the indictment, which alleges the offense of manslaughter. And in pertinent part, it says Jasmine and Zuvette Hardaway did recklessly cause the death of an individual namely Quanit Yvonne Campbell, hereinafter referred to as complainant, by striking the complainant with the hand of the defendant. Now, the essence of this defense motion to quash the indictment is that under the unique circumstances wherein the state alleges a given defendant acts recklessly, the state has to set out those facts that constitute reckless behavior on the part of the defendant unless they are inherently dangerous to human life. It would be the state's, or the defendant's position that the current language of the indictment wholly fails to do that. And in support of that argument, I would call the court's attention to Article 2115 of the Texas Code of Criminal Procedure, along with Flores versus State, 536 Southwest 3rd, page 560, Texas Court of Appeals, San Antonio from 2017. And I think it's important to note that the Flores matter is a case out of this trial court with this same allegation. And the Court of Appeals held that under the facts asserted in Flores, that the indictment was insufficient and should have been quashed, and that it was error to do so. The court went on to hold that it was harmless error. However, nevertheless, it was alleged, or it was stated, that it was in fact error to deny the motion to quash. It should also be noted that the state of Texas, along with the appellant in Flores, both filed petitions for discretionary review. The state filed a petition for discretionary review asserting that the trial court did not err in failing to grant the motion to quash, and that the Court of Appeals erred in finding so. Flores filed a petition for discretionary review asserting that the error was not harmless. Both of those petitions for discretionary review were denied. So what the bottom line is that language in Flores is of a nature that should have been quashed by this court. And I would respectfully submit that the indictment, as it, in the instant case, as it is presently constituted, suffers from the same defect. And that in ruling on a motion to quash prior to trial, as opposed to an appellate court ruling post-trial following a conviction, harmless error does not come into the play of an analysis that should be employed by a trial court. Hence, the Flores opinion, the portion that applies herein, is the portion that addresses whether it was error to fail to grant the motion to quash based on that deficient language. And we would urge that I do not see valid distinction between Flores and this case. I cannot imagine how it can be stated with any degree of affinity that striking someone with your hand is an act clearly dangerous to human life. That would require, I believe, further definition of the acts committed allegedly by my client that constituted reckless behavior on her part. And whether or not the state could prove the allegation as it's presently worded is another question. But nevertheless, it's our position that under the holding in Flores and Article 2115 of the Code of Criminal Procedure, that the instant motion should be granted and that there is a written order to that effect pending before the court. And I should also note that we could theoretically have this case or this issue decided if the court were to grant the motion to quash. Then the state could act within their rights by seeking to appeal that ruling on the straight legal question of whether or not this indictment is sufficient in the face of a motion to quash without having the issues relating to harmless error muddying up the issue before the Court of Appeals. It might as well be decided one way or another before trial, and the state has the authority to take it up if the motion's granted. The appellant or the defendant enjoys no such right. So in the interest of judicial economy, if nothing else, grant the motion, let the state take it up. They have plenty of people to do the work. Thank you.
All right, State?
Oh,
you,
Your Honor,
Judge.
one other thing, Mr. Wanted to say Spears. Marcus provided me with case law and he gave you copies. So the matters that he's presenting you to, I already have. Thank you.
All right, thank you. All right, State?
Yes, Judge. I guess to respond to Mr. Shaughnessy's last comment, essentially he's suggesting that the court should grant a motion in this situation, as well as, I mean, the same would apply to a motion to suppress because the state can appeal that also. And so by Mr. Shaughnessy's reasoning, every court should grant a motion to suppress because the state can appeal that and then we can do it all over again. As far as the Flores case, our argument is that that case is distinguishable from this case at hand. Yes, they are both manslaughter cases, but they are different. There are a different set of facts. The Flores case involved a vehicle, and the issue in that case was that the indictment alleged 3 different manner and means. It alleged that the defendant drove in excessive speed. Yeah, so by driving and operating a motor vehicle at an excessive rate of speed above the posted speed limit, and by driving and operating a motor vehicle straight through a left turn only lane in an attempt to pass another vehicle, and by racing another vehicle in a public place. The entire argument in the Flores case was that because the first alleged manner and means, which was the excessive speed, isn't inherently reckless, that the indictment did not provide sufficient notice to defense. And that's clear because the court and defense in that case gave a lengthy argument about how every day people drive excessively in excess of the speed limit. But how is that reckless in the sense that they know that there's a substantial risk of injury or death? And so I guess our argument is that in this situation, we've only alleged 1 manner of means. It's that the defendant, by striking the complainant with the hand of the defendant, or sorry, by striking the complainant with the hand of the defendant. We argue that that's sufficient. To require us to do any more would be to require us to plead evidentiary matters, which is not required by neither the Constitution or the Code of Criminal Procedure. I provided the court and defense with a few different cases, some out of San Antonio, some out of other courts of appeals. The Arroyo v. State, 64 Southwest 3rd 81. In that case, it was an assault case, and it was alleged striking the said complainant with the hand of the said defendant. It was argued under 2115 that that wasn't sufficient notice, but the court found that it was. There's State v. Rogers, 214 Southwest 3rd, 644. There were a few different allegations: pushing the body of Ashley Guillory with his hand, kicking the body, striking the head, and choking. Argued under 2115, and that court held that the indictment was sufficient. There's Ex parte Cano, which was an unpublished opinion out of San Antonio, a 2008 Westlaw 4500306. In that case, it was alleged by striking the complainant with the hand of the defendant, and under 2115, the court held that that was sufficient. And then we have also State v. Levitt, another unpublished opinion, this one out of Dallas. It's alleged by hitting the complainant in the face with the hand of the defendant. They argued under 2115 it wasn't sufficient, and the court held that it was. For the court to hold that striking, I guess the difference is that, one, striking someone is inherently reckless. Second, for the court to hold that it isn't would mean that essentially any assault case where we allege striking would not be sufficient under 2115. And just to cite, let's see. It's out of the Beck v. State 682 Southwest 2nd, 550. The state, however, is not required to plead evidentiary facts which are not essential to provide the required notice to the accused. In this situation, the state has alleged the acts that we are alleging the defendant committed that were reckless, and that's sufficient. Going back to one of the other cases I cited earlier, and actually, I didn't cite this one yet. State v. Manual 873 Southwest 2nd, 108. This was, oh, maybe I did. No, okay, this was an opinion out of Dallas, 873 Southwest 2nd, 108. It was alleged by striking said complainant with a belt. Defense argued that it didn't allege how striking was reckless. The court held that the indictment was sufficient, or the information was sufficient. And specifically, the last paragraph says, we conclude that the indictment in this case is sufficient because it adequately informs the manual of the act the state relied upon to constitute recklessness, namely striking the complainant with a belt. Further pleading about how Emmanuel hit the complainant with the belt or the seriousness of the contact would be evidentiary pleading beyond the requirements of Article 2115. So in summary, Judge, we argue that the Flores case is distinguishable and isn't binding on this court, that the indictment is sufficient as alleged under the Texas Constitution, the US Constitution, and Article 2115. So we ask that you deny the motion.
All right, defense, it is your motion, so I'll give you final argument.
Yes, Your Honor. Well, for starters, Flores is binding on this court.
Oh, just one second. Mr. Shaughnessy,
Oh.
if you could face this way.
Looking the wrong way, got me.
Yes, no, it makes it easier because
I
then
get it.
Brenda can see your lips.
I get it. Your Honor, first of all, Flores is binding on this court. Whether or not it's distinguishable is another question. We believe that that's the most recent opinion on the matter from the Court of Appeals here. And there are any number of opinions that could be found by the court that talk about whether the indictment is legally sufficient to charge an offense. But it's important in this case that we are alleging more than that. We are alleging that it should be quashed, not that the indictment is fundamentally defective by failing to charge an offense, which is a radical difference. Secondly, with respect to Mr. Sanders and his assertions regarding motions to suppress, this is also radically different because this is a straight legal question that could come up again. Motions to suppress are inherently factually based, that change from fact to fact to fact. This is not one of those things. This is just a straight legal question on whether or not Flores applies to this indictment. And it could be decided by the Court of Appeals. And I have no reason why to offer to the court why it shouldn't be decided by the court. It would be fundamentally unfair to Ms. Hardaway to have to go to trial and potentially get convicted on the indictment it is presently worded, and then take up the issue of the motion to quash and have to fight the question of whether or not it was harmless error. When presented with facts like this, with the holding of Flores, I don't see a way around the argument that the motion should be quashed. And that's all I would have. Thank you very much.
All right, thank you. Everyone, if you all will just give me a moment, please.
Can I turn the other way?
No, you're fine. Everyone, I'm going to open breakout rooms because there are a couple of people who need to go to a breakout room. Please don't go to a breakout room though, because Mr. Shaughnessy, it'll be inviting you and everyone else. So no one goes unless I specifically move you. So no one else is to go. Just give me a moment, please.
Nothing yet. No, she's reading something. I don't know if she
Hello, everyone. We're back on the record. Miss Jasmine Hardaway.
Yes, ma'am. Sorry, I was cleaning my face. Sorry. Yes, ma'am.
All right. So we're back on the record. Mr. Shaughnessy and Mr. Sanders. The case law I received from Mr. Sanders, I received it right before the hearing. And I don't read anything that the state or the defense gives me until I know that both parties have reviewed it. So it's not ex parte. I know things are a little bit different because we're all by Zoom. And if we were in court, then it would have been given to me much sooner. But I know Mr. Sanders was clearing it with you. So what I'm going to do on this case so that I can read all the case law that Mr. Sanders has given me, because there is one case that I'm not familiar with that he's given me. I am familiar with the Flores case. So we're going to come back on Tuesday at 9. And at that time, I will, are you not available, Mr. Shaughnessy?
Judge Harrell has some pre-trial or some, I guess you would call them, what's he calling them? Pre-trial conferences on a dozen cases set for trial.
Well,
I will be available that date, but I don't know if that time would work.
well, is another day in the week good for you other than Monday?
And Judge, not,
Hold on.
I know that another ADA could sit for me, but I'll be out Monday through Wednesday. So if it's possible to have it later in the week or early next week.
Are you all okay with Friday?
Well, why can't I go somewhere with Marcus? I mean,
Well, if you all want to go on a trip together, you can.
I want to go somewhere.
Be sure to wear your mask and socially distance.
Your Honor, I mean, that's fine. Anything to accommodate Mr. Sanders. He's been very generous with his responses to everything that's been filed.
Okay. All right, Norma, then can we recall this case on May 28th at 9?
Yes, ma'am.
All right, so Ms. Hardaway, we're going to come back and you can be by Zoom. We're going to come back on Friday at 9 a.m. because I want to make sure that I read all of the case law that's been given to me by the state as well. And at that time, I'll give you my decision on your counsel's motion.
Okay, Judge, is there any, can I talk?
You may want to clear that with your counsel
Your
first.
Your Honor, I think what Ms. Hardaway is going to be asking the court is if you could put her on tracking only GPS.
All right, if the state is not in agreement to tracking only GPS, then we can take that up as a hearing and we can take that up on Friday as well.
I was wondering what Mr. Sanders might think about that.
You give me a couple minutes to look at her history. I can have an answer for you.
You bet.
So if there is an agreement, then we'll take care of it. If not, Ms. Hardaway, we will take that up on Friday as well.
Wait, I just want to go to my daughter's graduation, but okay. Okay, thank you. Okay. Is it over?
No, it is not.
Oh, sorry.
Hang in there, Jasmine.
Mr. Shaughnessy,
Your Honor, yes.
if you have an agreement with Mr. Sanders, if y'all will send it to me by email, and who knows, Mr. Sanders may agree to her being allowed to go to graduation. I think the main current concern, Mr. Sanders, she said she wants to attend her daughter's graduation.
Judge, we have no objection to tracking.
See, there you go. So if you all will send the email to me for tracking, then I will sign it and it will be for tracking only.
Thank you. I already missed her birthday. Sorry. Thank you.
Oh, here's the thing. I know that, and we're off the record, Brenna. Here's the thing. I know that people say that birthdays are the thing to be, but guess what? To me, you should celebrate somebody every day, not just on their birthday.
Yeah, but my
So
daughter's
she's
sick.
here's the thing, she's gonna have another birthday. And then when you get with her for her graduation, you can celebrate graduation and birthday rolled into one.
Thank you.
You're welcome. Is there anything else from either side?
Well, if I could talk to Mr. Sanders about getting this order before the court.
Yes. All right, what I'm gonna do.
But other than that, we don't need the court anymore.
All right, great. What I'm gonna do is I'm gonna stop live stream. Everyone, please have a safe weekend. Keep in mind, COVID is still happening. Wear a mask, socially distance. And if you want to be around me or come near me in the courtroom and in chambers, please wear a mask. All right, so we're gonna stop live streaming now, and everyone